Okay, it's 11 o'clock. I know there may still be people who are joining, but I'm going to go ahead and get started just because I have an hour. So my name is Courtney Milburn. I'm an officer at the Employment Standards Branch. I'm based out of Richmond, but I work with our compliance team, which works a lot in the agricultural sector. And today I'm going to be giving a quick overview of the Employment Standards Act as it relates to the agricultural sector. If you have questions while we're going through, please feel free to raise your hand or take yourself off mute. I may not see you, so you can chime in. Um, I want to ensure that I'm answering the questions that are pertinent to you if they come up as I'm going through it. And if I'm going too fast or you miss something, also please just let me know. This can just be a conversation as well. Um, so the Employment Standards Act is what guides our work here. And the purposes are the act, they are to ensure that all people in British Columbia receive at least the basic standards of compensation and conditions of employment. The purpose is to promote fair treatment, to encourage open communication between employers and employees, and to provide fair and efficient processes for resolving disputes and interpretations of this act. So it's also here to develop and foster productive and efficient labor forces, and also help employees to meet work and family responsibilities. So not everyone who works in BC may be covered by the Employment Standards Act. There are people whose work will fall outside of it. That includes anyone who's under collective agreements or unions. And there's certain occupations that are excluded from the act because they might be within federal jurisdiction. So when you have things that cross provincial boundaries, like the mail service or long haul truck drivers, those ones actually fall within federal jurisdiction because they're crossing those boundaries, or they work on waterways or things which are not in the jurisdiction of British Columbia. We also have things like if somebody's in business for themselves, like so they're an independent contractor, their employment relationships with anybody where they're getting employment, they would not be falling under the act either. So we have a definition of employee and employer, which I will get to, because it is sort of important because sometimes these employment relationships can be blurry because someone comes and helps somebody or does things. And so because some of these things can be nuanced, we always fall back on our definitions. So the things I'm going to be talking about today are both the Employment Standards Act and the Employment Standards Regulation. So the Act is there to provide the minimum standards, the rights and entitlements, and regulation. It for a lot of it may limit or take away entitlements based on some definitions or different areas of work. So an employee, this seems simple, but it's important that we sort of define these things because not everybody, as I say, if somebody's an independent contractor or those sorts of things, like there can be nuances. So, but what it is, if you are receiving or entitled to wages for work performed for another, an employer allows directly or indirectly to perform work normally performed by an employer or employee, or they're being trained by an employer for an employer's business, or they're on leave from an employer. All those people fall within the definition of being an employee. Who's an employer? This is someone who has control or direction of an employee or who is responsible directly or indirectly for that employment of that employee. And so within the agricultural sector, it's also really important that we define what is a farm worker. And we do this because there are special rules and things for farm workers. So the Act defines a farm worker as someone who is employed in farming, ranching, orchard, or agricultural operations whose principal employment is the responsibility consisting of any of these. So growing, raising, keeping, cultivating, propagating, harvesting, or slaughtering the product of a farm or ranch operation, which is pretty, like that's the most of what we see, right? But also it can include clearing, draining, irrigating, or cultivating land. So that is the things that take place before the harvest season or after the harvest season. I mean, getting ready for planting or harvesting. So operating or using farm machinery, equipment, or materials for the purposes of either grow or A or B, so that, tending the land or harvesting and propagating crops. It also includes the direct selling of products if it's done during the normal harvest season for the product and it's done at the operation. So that would be something like if there's a blueberry farm, say, and they have a stand on their farmland. And during the time that blueberries are in season, they are also selling them. That person who's working there selling those is also considered a farm worker. So what farm workers do not include is a person employed to process any of the products from farming outside of initial washing, cleaning, sorting, grading, or packaging during a normal harvest season, or done by where they're getting it from another farm also during the same harvest season. And I just want to draw specific attention to this because sometimes there's a little nuance here because somebody who's working, some might have, say, where they are having products frozen after that. And if somebody's working in there, that person is not a farm worker, right? Because that goes beyond the initial washing, cleaning, sorting, or grading or packing. We're looking at fresh produce and it has to be of a farm. If a farm operation also gets product from another farm, it also has to be within that same harvest cycle. So if somebody's getting, say, mangoes imported, that's not something that we typically see within a BC harvest season, and that people who are working within those would not be considered farm workers. We'd be moving more into food processing at that point, and so they wouldn't have the same rules that farm workers have. It also does not include landscape gardeners or persons employed in retail nurseries, and it does not include any person in aquaculture. So the reason that we kind of really want to define farm workers is because the regulation has exemptions for them. So farm workers they're exempt from overtime pay requirements and statutory holidays. So if somebody is working on a farm and, typical overtime is after 8 hours in a day, that does not apply to farm workers, which is why we want to be really clear on who's included and who is not included in farm work. However, farm workers are entitled to protections from excessive hours detrimental to their health or safety. So just speaking broadly of the Act, the requirements of the Act and regulation, those are the minimum requirements. Those are what everybody is entitled to at the minimum. They aren't like, people can agree to more, but they cannot agree to less. And because these are the minimum requirements, even if somebody makes an agreement, like let's say, minimum wage is $17.40 an hour, but they make an agreement saying, I'm going to work for $10 an hour, even if you've signed it, even if it's been notarized, it has no effect. It's meaningless. You cannot waive the requirements of this act. And because the employment standards regulations exclude people from some of these minimum requirements, we interpret them very narrowly, which is to say, if there's a question as to say, for example, if someone is a farm worker, we're going to really look at narrowly applying it. So if some or even 51% of their job includes things that are not farm work, we're likely not going to find them to be a farm worker if there was a dispute on the matter. Okay, and speaking of agreements, because you can't waive your standards, any agreement that's agreed upon between employers and employees has to comply with the Employment Standards Act. It's benefit conferring legislation, which means that it's going to be applied broadly and inclusively. That is to say that we're going to look at what is most beneficial to giving someone the benefits of the legislation. So work. Sometimes this comes into dispute, people agree to come do something. Some people might think it's a favor. These things happen. Sometimes we get, these sorts of disputes that come to the Employment Standards Branch. And so once again, it's like we're always going to look back at our definitions. Work includes the labor or service an employee performs for an employer, whether that's in the employee's residence or elsewhere. And an employee is deemed to be at work while on call at a location designated by the employer, unless that location is their home. If someone says is at their own home, they're not considered to be at work unless they're actually doing work or doing a service. But this doesn't really apply so much in agriculture, but if somebody is designated, like you have to go to, this location and wait, if they have to go a specific place or be in a certain area, then that would be deemed work. So wages. Employees must be paid wages for all work they perform. That includes training, staff meeting, travel between job sites. So it doesn't necessarily mean that travel from home to their first job site, but if after that point they then have to travel to different locations, all of that is still considered work. And regardless of what pay structure they're under, you have to be paid the minimum wage for all hours worked in the pay period, and you must be paid in Canadian currency. So minimum wage on an hourly basis right now is $17.40, and this does change. And so it's always important that you're aware of that. There's other kinds of ways wages can be paid, and we do see that in farm work, specifically around piece rate. And so I have the piece rate here as it sits currently, and it's important to remember that piece rate is inclusive of vacation pay, as long as you're paying within these minimum wages for the piece rate crop. And if you are choosing to pay by piece rate, you have to display in a location where it can be read by all employees the volume of each picking container being used, the volume or weight of fruit required to fill that container, and the resulting piece rate. And that piece rate must comply with obviously the minimum wages. So how wages are paid. It does happen a lot that we do see disputes around sometimes employers only paying monthly or, having all their wages, just in certain periods that don't comply with the act. So it's important you have to remember there has to be at least 2 pay periods each month. And a pay period cannot be longer than 16 days. So all the wages capped that are earned in one pay period must be paid within 8 days at the end of the pay period. So unless if an employee is terminated, they have to get by the employer, they have to get all wages within 48 hours. And if an employee quits, they have to be paid all wages within 6 calendar days. So an important employer responsibility is to have wage statements. So this is a requirement. They have to have names, addresses, the wage rate, whether it be piece rate or hourly. They also have to include the hours worked. If they're entitled to overtime, all of that information has to be in there. If they're entitled to stat pay, all of that information has to be in there. And yes, if you're paid by some other way that isn't like outside of hourly, you have to explain how that was calculated. So your wage statement also has to include any money, allowances, other payments the employee is entitled to, and the amounts and purposes of all deductions. So typically that is just statutory deductions, taxes, that sorts of things. But sometimes with farm housing, they might have to pay, if they're paying like a rent agreement on there and you have an agreement with them to deduct that rent from their wages, we would want to see that on the wage statements as well. It has to include their gross and net wages. And if there's a time bank for, if their holiday pay, sorry, their vacation pay is in a time bank, how much is accruing or being used from that bank. So they can physical copy or electronically, they have to be able to access their wage statements. And this is a sample just of like what one could look like. It has the company's name, the employee's name, the date in which it's valid, and here you see the breakdown of their hourly rate, the hours worked, the total, here's the deductions. These are pretty standard and pretty typical, but it's always good to point out that this is a requirement. So wage statements have to include all that information. I feel like maybe I've already kind of gone through these. Oh yeah, and things like gratuities, that stuff isn't as relevant for agriculture. And deductions. So statutory deductions are obviously allowed: income tax, EI, CPP, and any garnishing like family maintenance. There are other deductions that are allowed, but you have to have written consent, and those can include medical and dental benefits, union dues, charitable donations. And as I said, like if you have an agreement to have housing on site, which there is a cost associated with it, it should be in the contract, and there should also be an agreement that they agree to in writing to have that amount removed from their paychecks prior to having that removed. Okay, there are also deductions that are not allowed. So business costs is a big one. Like say somebody damages something on the work site, an employer cannot decide to unilaterally remove that from their paychecks, nor can they decide to just withhold wages pending anything. Wages, the employee has a right to have their wages, even if there is a business cost that may be, there's something they've damaged, that's not something that you can like try and deal with through their payments, through their wages. So you can't have any deductions in there as you see damage, theft, all those sorts of things, uniform costs, hiring fees. None of that stuff can be deducted from people's wages. Yeah, and then farm labor contractors, I wanted to touch briefly on this. There wasn't really a place to put this. I know they are less common in the Okanagan, which I understand is sort of the area that is going to be looking at this. However, it's still important to kind of understand these. So farm labor contractors, they provide labor to producers being the farms. And so they can get short-term labor usually to help with planting, cultivating, harvesting of agricultural products. So the farm labor contractor can take their workers to a variety of farms owned by different producers. And the farm labor contractor, they are the employers of these employees that they're bringing. In order to work in this business, they must be licensed. They have to be licensed through the Employment Standards Branch, and there is a process for them to do that, and there are special rules that apply to them. It's important, and the reason I mention this is because anyone who has an unlicensed farm labor contractor, so say another producer wants to have another farm borrow their workers and they're still going to pay their workers for that time, they are now considered being acting as an unlicensed farm labor contractor. And the issue for the producer who is borrowing those workers is if there was a dispute that came to the branch, they would be considered the employers of these workers and could be liable for any wages owed to them. So it's just something to remember. We have the list of who or what contractors are operating, and who is licensed is publicly available information. You can just look on our website. You can also just even print into Google like Farm Labor Contractors BC, and usually you can find the list that way. It's just something important to know, like as it does happen where people have workers and they're wanting to sort of shift them from place to place, that there is rules preventing that to happening unless it's a licensed farm labor contractor. So the next couple slides I'm going to go through somewhat quickly because these deal with the hours of work piece, which farm workers are exempt from. However, there are always people on farms that are not farm worker supervisors, various other staff, support staff, these kinds of people for which these things do apply. And so it's kind of important to know and it's to be aware of like who's falling within those different definitions and not. If they are not farm workers, these kind of information applies. So I'm going to go through it quickly as I say. So minimum daily hours, if somebody is scheduled, and they come to work, but then there's no work for them that day, they are entitled to 2 hours of pay at minimum. But if they're scheduled for more than 8 hours in that day, they're entitled to 8 hours. However, there is exceptions. If somebody shows up to work, say on a job site where they're required to have like safety gear of some kind and they just didn't bring it, well, then they don't have to be paid for the hours they did not work. If they're unfit for work in those ways. But everyone else, if they show up for work and there turns out to be no work for them that day, they're entitled to minimum daily hours. Breaks, they get one 30-minute break after 5 consecutive hours of work. And breaks must be paid if they're required to be available for work during their meal break. Like they can't fully leave a place, they have to monitor something. In those situations, they should be paid for that 30 minutes. Either way, they're required to have the 30 minutes. So there's rest periods that are required between shifts. So 32 hours free from work each week and 8 consecutive hours between shifts. So a shift ending, at midnight one day can't start before 8 a.m. the following day. Overtime. So as I say, this isn't something that usually it doesn't apply to farm workers. However, it is good to know. So regular wages are paid up to 8 hours in a day, 40 hours in a week, and daily overtime after 8 hours in a day is paid at 1.5 their regular rate and 2 times their regular rate after 12 hours. Weekly overtime is paid at a rate of 1.5 after 40 hours in the week, counting only the first 8 hours each day. So this is an example of overtime. I won't spend too much time on it, but you can see how this sort of breaks down. To see how they would calculate, say, like weekly overtime. It's using these first 8 hours to find out how many were worked or how many additional hours. So there are exclusions from overtime. Obviously, as we already said, farm workers, managers, as long as they fall within our definition of manager, anyone on a valid averaging agreement, and variances that are granted by the Employment Standards Act. Variances, I won't get into too much, but it's basically just something that between an employer and employee, they both agree that there's some part of the act that they would like to have varied for the benefit of both parties, and they can apply to do so with the Employment Standards Act. There's only certain areas, which includes overtime, that can be varied. Common misconceptions that salary means that you don't get overtime, and that overtime is payable over and above salary. Yeah. So stat holidays, once again, this is not something that farm workers would be entitled to, but for all other employees, it would still be something to be considered. So to be entitled to stat pay, you must have been employed for 30 calendar days and have earned wages in at least 15 of the 30 days prior to the holiday. This includes managers and farm workers. So these are our current statutory holidays. And so if an employee doesn't work on these holidays, they're entitled to an average day's pay. Average day's pay is just calculated for most people. If they're working full time, that's 8 hours usually, is what their average day looks like. If they work that holiday, they get time and a half for up to 12 hours and double time after, plus this average day. So vacation. So there's vacation time and vacation pay. For vacation time, it's earned during the first year of employment, and then you can take it in your second year of employment. They have to be given at least 2 weeks free from work after 12 consecutive months of employment, and at least 3 weeks free from work after 5 years. And this is the same as the 4% and the 6% in terms of vacation pay. So annual vacation time. Employers must ensure that employees take their earned vacation within 12 months of it being earned, meaning that first year they earn 2 weeks, the next year, the second year, they have to take it within that 12-month period. Employers must allow employees to take vacation in week-long periods. They can't force them to break it down into smaller chunks if they don't want to. Employers can decide when vacation time is allowed in alignment with operational requirements. So say for farm work, if there's, obviously the busy season, whenever the crops are coming due, an employer can say, no, there's no vacation time in August and September. We don't do it during then. And that's absolutely fine. So vacation pay is after 5 calendar days of working for an employer, an employee becomes entitled to vacation pay, at least 4% of their total wages. So you have and 6% after 5 years. And just keeping in mind that anybody with piece rate, that amount is already included in their piece rate amount if they're paying by that. They're paying minimum wage, vacation pay is calculated on top of that. Vacation pay may be paid on each check if the employer and employee agree in writing. Vacation pay becomes payable at the end of the year in which it's earned and must be paid within 12 months of the anniversary date. So similar to vacation time. You can set a common anniversary date for all employees, which means some workplaces just out of simple, necessity, just say January 1st, that's our anniversary date. That's when everybody gets their earned vacation. And prior to that, they prorate. And if employment ends, any banked vacation pay must be paid out with their final wages. I'm just going to pause here. This is sort of my halfway point. I know I zoomed through a lot of these payment things. The next things I'm going to be getting into is that end of employment piece, contract, that kind of thing. But is there any questions or concerns or things that I went over maybe too quickly or missed that anyone would like clarification on?
Yeah, I have a question around managers, if they would follow kind of the regular ESA, would at any point they fall under farm, well, not a farm worker, but kind of under like an agricultural employment standard?
Yeah, so that's a great question. So managers, there's a definition we have for managers, and it's important once again to go to these definitions because there's a lot of workplaces that may use the word manager, but it doesn't actually meet what the Act says a manager is, because they have to have a certain amount of responsibility to fall within that. And once again, it's because they may not be entitled to overtime if they're a manager. So manager, we define as a person whose principal employment responsibility is a supervising or directing human resources or other resources, or a person employed in an executive capacity. So they're making big decisions for the employer. You know, they might have huge budgets that they're managing. We see those as an executive capacity. We often see people who are more supervisors of a workforce. So they're doing predominantly the same work as the staff, but they're also the supervisor. Those people are less likely to be found to be managers. Managers, we would see it's like that they are just spent, their day is spent basically managing either resources. So on a farm site, they might be managing like where the equipment's going, what's happening with crops, when things are being harvested, that sort of thing, like they're managing the resources, or they're managing the staff, which is mean they're figuring out where people are, what they're doing, what their productivity is, that sort of piece. Both of those may be considered managers. And if they are a manager, then they are not entitled to overtime, but they are entitled to ensure that they're always getting a minimum wage. So often you see managers have like their salaried employees, where they get, you know, whatever it is, like $50,000 a year. However, if the hours they're working make it so that 50,000 doesn't meet minimum wage, well, then they would be entitled to further wages to ensure that they're always making at least minimum wage based on the hours of work. Does that kind of answer your question, or was there anything more specific I could clarify?
That does answer my question. If you wouldn't mind that the last part, maybe going into a little bit more detail about
About
that.
the minimum wage piece?
Yeah, yeah.
Yeah, it's so basically sometimes managers, because there's no, they might say like, okay, you get 50,000 for all hours of work. This is going to depend on the contract, right, of each manager, because some contracts may say you're going to work 40 hours a week and you're going to get $50,000 a year. And if that happens, if they work any more hours, they should get more wages for anything over the 40 hours in a week. However, other contracts might not note hours at all. And they just say you get $50,000 for your job. And your job might take whatever hours it's going to take. And you find, wow, this job is a lot. And I actually end up working, 80 hours a week. Well, if you then are looking at your wages and you're like, wait a minute, when I actually calculate this all out, I'm getting $10 an hour because I'm working all these hours. Well, then that's something you'd want to bring to your employer, because they have a duty to at least pay minimum wage, the 17.40 an hour. And so it depends on the contract. That's why I tell anyone, manager, farm worker, whoever, that it's like always look back at your contract to ensure that it's one, meeting the minimum standards of the act, but two, that you have a clear understanding of what your wage is, and what it's tied to in terms of like your productivity, your hours of work, those sorts of details. Yeah. Is there any other questions? So managers, farm workers, any of the things I've sort of gone through, wage statements, wage rates?
I have another question. I don't know if
Mhm.
you'll get into this a little bit more, but average agreements.
Oh,
Um,
I did not have them on here. What's your question about? I can definitely get into that. Oh no, yeah.
um, so I understand that average agreements are meant to be temporary in nature. But because farming in general is more cyclical,
Hmm.
um, and average agreements, I believe it's like a 4 week kind of time frame. Is there something that is more long term for a farm worker?
Yeah, so they can be, you can average the work over 4 weeks, but they can last longer than 4 weeks, if that makes sense. So they can repeat numerous times. They aren't meant to be a long-term solution. It's true. But when people have these things, you can basically say, okay, week one, they're working, 50 hours. We don't really see it with farm workers though, because the reason people average hours is to kind of like, because in one week they might work no hours and the next week they're working 80 hours. And so they're saying, well, between the 2 weeks, it works out to 40 hours a week. And so we're going to make this agreement so we don't pay overtime. But farm workers already don't receive overtime. So they'd still be required in either case to be paid for all hours of work. But if there is a case where somebody maybe doesn't fall within the definition of farm work, like they're a farm worker supervisor, where they're also like working and managing people in some way, or they're working maybe in sort of some area of production with the produce that falls beyond that initial sorting cleaning piece, in which they would now this would be an issue. If they were under an averaging agreement, they can average the work over 1, 2, or 3, 4 weeks. So for example, the one I gave where they're working 80 hours in week 1 and no hours in week 2, and they want to average that over 2 weeks then. And then so basically with these to be valid, they have to agree in writing, they have to have a start date and an end date, how long the agreement goes over, and they have to have a very specific work schedule, which also makes it really hard in farm industry where, you know, the dates and work can change, right? Because they're dependent upon so many other elements and weather. However, with an averaging agreement, you need to have like Monday, you're working 12 hours, Tuesday, you're off, Wednesday, so that they know exactly what days they're going to be working. That's what, to have an averaging agreement, that has to be in place. And so if they can't do that, then they don't really work because they're highly structured. But in terms of having these long-term, what a lot of employers do if they have like, usually permanent non-cyclical employees, they would look into applying for variance agreements through the Employment Standards Branch, where they can have long-term between 2 and 5 years agreements with specific staff or specific positions to vary pieces of legislation, including the overtime, which was to say like that they would have like these kind of what looks like an averaging agreement, but over long term or possibly longer periods. So the averaging agreement only allows you to have it for 4-week periods, but variances don't have those restrictions and can be done over some other agreement that the parties both want. Does that make sense? It's a little bit it depends like on each individual situation, so it's hard to give general answers in these cases.
Yeah, no, it does. The variance piece, I think
Yeah.
I'll look into that a bit more for sure. Thank you.
Yeah, absolutely. And with those, it's like we have online applications for those, and they can be really helpful for long-term employees and also help employees kind of just know what their work schedules are going to be. It's usually seen as a big benefit to employees if they can sort of agree, because often it means they get more time off chunked together, right? When workplaces are doing things like 1 week on, 1 week off, or various other things that an averaging agreement wouldn't allow. Okay, so I'm going to jump into the next section, which is just on compensation for length of service. So this is when employment ends. So the compensation for length of service, this is often called termination pay. Some people call it severance, but severance also can have different meanings. So termination pay is common. So this is your entitlement. If somebody works for less than 3 months, there is no entitlement. After 3 months, it's 1 week. After 12 months, 2 weeks. After 3 years, 3 weeks of wages, and then 1 week per year after that for a max of 8 weeks. Compensation for length of service is not required to be paid if an employee quits or retires, or if an employer provides notice. So if somebody's worked there for 8 years and 8 weeks before their employment ends, you tell them like, look, your employment's going to come to an end in 8 weeks. You would not then also owe compensation for length of service. You can also do this in combination. If they had worked there for 8 years and you gave them 4 weeks notice and then 4 weeks of pay, that's fine as well. It's also not required if they are terminated for cause, or fired is often the word for it. So if they've done something that has justified their firing, then you don't owe that. But it's important, and I want to draw attention to this, that the onus is on the employer to provide that liability was discharged, meaning that the employer has to be able to show that they had that cause to fire someone and that they don't owe compensation for length of service. So making sure that you have really good, processes to document what's happening in your workplace is very critical. So I just want to, because this is very common in seasonal work, just to speak about defined terms and temporary work. So if an employee is employed for a defined term, meaning that they know at the start of their employment what their last day is going to be, because they're, whatever it is, then compensation for length of service would not be owed. If they're hired for a defined term and then they're let go before the end of that term, they would be entitled to compensation for length of service. So the other one that we would not be required to pay is if they are coming on these temporary basis. Often you see this with people who are on call status, where they can be called out to be like, hey, can you come in tomorrow? And that person can say yes or no without any penalty, meaning they're still going to be on the call out list. They might still be called in. Those kinds of arrangements don't require compensation for length of service either. So just to kind of go into that just cause piece, because it does come up a lot in our work here, it's something we see disputes on a lot, is there's two kinds. So there's major misconduct and minor misconduct with just cause. So major misconduct is something that it can only happen once. It's a serious and deliberate, intentional, or fundamental breach of the employment contract. And something happens, like somebody steals something from the workplace, and obviously after that, that's a huge breach. And so they do that and they are terminated that day. They're fired, like a one and done. It isn't like you're giving them like, hey, warnings, that kind of thing. Those are major misconduct events. And so we would once again want to see if this happens, that you document what's happened, that there's clear documentation that they've been told what happened, whatever it is, and they've been terminated. That would be a just cause termination we'd see sometimes. And once again, it's just about we want to ensure that we're seeing documentation if this does happen in the workplace. And the other kind is minor misconduct. This one we see a lot of, right? Somebody's always late or they're not doing their work properly. They don't show up. There's little things. And it's not just like if somebody's late one day, we wouldn't expect or accept that that was a major misconduct event. However, if they're late every time, we just want to see that you are establishing there's steps to take before you could call that just cause termination. And that would be in talking to them, communicating what the employment standard is, which could be as simple as like, hey, work starts at 6 a.m. If you're not here and ready to work by 6 a.m., you're considered late. And if this happens X amounts of time, then that would result in potentially you're going to be terminated. So you can see that that's the steps here. You basically let them know what the standard is. Work starts at 6. You give them time to meet the standard, meaning that, obviously they're still employed. You have the expectation and perhaps they start meeting it and no problem. But if they continue not to, you're going to give them warnings of letting them know that this is going to result in their termination. Sometimes they'll say like, listen, if it happens again, you're terminated. And then you can show that they're still not meeting the standard. So when we get these as people file disputes saying, hey, this didn't happen, these are the kinds of things we're looking for. Was this a major misconduct or a minor misconduct? And if it's a minor misconduct, what opportunity was the person given to fix their behavior, right? And I want to say, if you just are like, no, they're late, I don't want to deal with it, that's fine, but you may just have to pay compensation for length of service and they can still be let go. It's just whether or not you owe that compensation for length of service is the question. So it's just some things to remember with these is to document. Document if you're sharing emails or text messages with the parties, make sure you have a good place to keep those. Make sure that you're being clear in your communication with the parties. Because also employees will come to us, they have their communications, they have emails, they have text messages, they have the things that show what happened in their workplace. And so often, that's what we're looking for when we're sort of trying to figure these out. Obviously, we hope that they can be figured out between the parties, but in cases where we're involved, we're always going to rely on what evidence we have before us. So this happens a lot. There's disputes whether an employee quit or was fired. It happens a lot. And so it's one that I wanted to raise here specifically. So it's the employer's responsibility to show that they don't owe compensation for length of service. The default in benefits conferring legislation is that an employee has left their employment, they're owed compensation for length of service. So if an employer says, no, they quit, and the person's like, I didn't quit, I was fired, how do we figure those out? Well, there's what we call both a subjective and objective element to quitting. So we need to see that the employee formed an intention to quit their employment. That can look like a lot of things, that they emptied their desk out, or they sent an email saying like, hey, I'm resigning, or whatever it might be. And then objectively, they must carry out actions inconsistent with their further employment. So basically that means it has to be the employee's idea to quit. They can't be forced into it. If they've decided to quit, we need to see that subjective piece. And objectively, we need to see that they're doing things like they're not continuing to show up to the workplace, or they've they've left or they've found other employment, whatever it is, other elements that are telling us that they're not working there anymore. And that's sort of what we're looking at. If we don't see those, we might say, well, it sounds like they may have been terminated. So often that can look like employers like being really clear. Like if somebody just stopped showing up to work, well, what happened? We'd want to see that employer reached out to say like, hey, are you coming in today? Because somebody who wasn't fired, that's what you would do. Um, so we're just sort of looking into the logic of these situations when they come to us. But obviously, once again, it's our like what we'd love to have is that people are just having that open communication with employees, that they're being clear in what's happening. Like if you think somebody quit, follow up, ensure that that's what's happened. Hey, are you not coming back into work? Did you quit? I have you scheduled for next week, whatever it is, to show us what's gone on here. And, if the employee comes back to work, maybe it was a misunderstanding, great, then they're still employed. So for compensation for length of service, this is just another piece of it. So regarding layoff periods, which I know doesn't really happen a lot in agriculture, usually it's seasonal end of it. So if they last longer than 13 weeks in a 20-week period, they must be paid compensation for length of service. Or if there's a substantial change in employment, often called constructive dismissal. So this means in cases where there's been a huge change in something, a condition of employment, wherein they wouldn't necessarily have been fired, but their job has changed so much in some way, either in their wage has shifted, their job duties, their job location, in some way that would be seen as substantive change, then they may be owed compensation for length of service because it's like that they were terminated from their old job and given a new job completely. And so those are kind of dealt with on a case-to-case basis, but it's something to think about if employees are shifting between really different roles, or if you're changing payment structures in some way that is going to have a big effect on them. Obviously, raises aren't usually what we see that in, but if somebody's shifting and then it's like, okay, well, now we were paying piece rate and now we're paying hourly, and that has a big impact on their wages, that could be seen as constructive dismissal. So how do we calculate compensation for length of service? We look at their last weekly wages for the last 8 weeks where they worked normal or average hours, and then we divide that by the 8 weeks, and then we'd get a number that is their weekly wages. And then however many weeks the employer is liable to pay would be calculated by that week that we found out. Okay, and that's it for compensation for length of service. Does anyone have any questions about that one? It's kind of a big topic area for a lot of our work. I don't know if anything came up for anybody. It's fine if it doesn't. Okay. So I'm just going to go in briefly into protected leaves. These are somewhat new in the last 5 years, and so it's always good to remember these. So after 90 consecutive days of employment, there's 5 days of paid sick leave and 3 days of unpaid leave each calendar year. They cannot be denied by an employer, and no advance notice is required, and the illness can be physical or mental. So what can an employer do? They can ask employees to provide reasonable, sufficient proof that they are entitled to the leave as soon as practicable. Wow, that word, I struggled there. Partial sick days are not allowed. Even 1 hour off qualifies as the day for the purpose of this section of the Act. And paid leave is an average day's pay. So just as a reminder, there are other protected leaves. These aren't like paid leaves like sick leave, but parental maternity, family responsibility, critical illness, injury, death or disappearance of a child, domestic or sexual abuse, bereavement, and jury duty. So it's good to be aware of these unpaid leaves. And then this is just general tips for employer. So document, ensure that you're meeting these requirements. You have, we have Section 28 of the Act, which shows you how to maintain your payroll records, as we discussed, all the information that we need to have. Having documentation of the hours of work is a big one. Ensuring that you're having that information well documented, saved somewhere It's required to be kept, but it's one of the ones that does come up periodically where there isn't good record keeping. And that can be to the detriment of an employer, because if an employee comes and they do have a record, even if, we want to see your record, but if we don't have that, we're going to rely upon what we get from a complainant. Um, and the other thing is to clearly communicate with employees, especially regarding wages, hours of work, time off, terms and condition of employment, workplace expectations, and rules. Keeping documentation of these conversations and just being clear, maintaining open communication. These things can go a long way. So this is sort of how our complaint process works, because it does happen. Employers may sometimes be involved in them. But basically, we accept complaints that are in writing, delivered to the Employment Standards Branch. We have an online form. They can come in person. We have mail. We have fax. So whatever's happened that they don't agree with, whether it be their termination or somebody thinks, hey, I should have gotten paid overtime, has to be delivered within 6 months of their last day of work, or if they're still employed, within 6 months of when the contravention occurred. So once they have done that, there is a wage recovery period. We can look back 12 months for their employment in the period. So if they're still working, it's 12 months before the complaint was filed, or from 12 months from their last day of work. So what happens after that? So often we have resolution meetings, and these are usually the easiest and most straightforward for both parties, where, similar to this, you'd get on a call with an officer like me, and the employer would be there and the complainant would be there, the employee. And the goal of these meetings is to come to an agreement or an outcome. And then my role in those would be to explain how the act might interpret these, what might happen, what I'm seeing, and ask questions that might help the parties come to an agreement. Often these have good outcomes where there might just be a resolution, even if there are times where, somebody doesn't fully agree with the outcome. They might say, okay, but I understand. And either the complaint is dropped or the employer voluntarily resolves the issue, and everybody goes back along their way and the complaint is closed. Oh, sorry, I didn't realize I have a whole thing. So there you go. It's just to ensure that everyone's getting the minimum standards, and it's the quickest of our options. So there is also investigations. So if a resolution meeting, either the parties don't want a resolution meeting, or the resolution meeting was not fruitful and the parties still want to proceed, then we'd move on to an investigation, in which an officer like myself would call both parties, get their evidence, get their sides of view. This is when that documentation piece would be very, very important, where I'm saying, okay, if the issue was a quit versus fire, tell me what happened. What do you have to support what happened? How did you communicate with them? And then I'd issue an investigation report. It would summarize the information from both parties. And during this process, there may still be an opportunity for resolution, but if a resolution can't be reached, then it would go to report. And then a decision would be issued based on that report. And if a decision is issued and an employer has found that they do in fact owe money or have contravened the Employment Standards Act, there are mandatory penalties that they would have to pay alongside the wages they are owed. And that's sort of it for the investigation process. And so this is our website. Also, just Google Employment Standards Branch, British Columbia will lead you to our site. We do have a phone number that can be reached. There's language options. If you have general questions, I will say they can't, litigate your case for you over the phone. It's definitely going to be more general information that they can give. And in order to get anything more than that, you'd have to file a complaint. But if you do have questions and things like that, they do their best to answer as clearly as they can with the information before them. But there's always the caveat that they don't see there might be nuances to the case that they don't see. We do also have fact sheets that are available in various languages to sort of help people understand their rights under the Act and their requirements as employers. And then we do also have offices in Dawson's Creek, Kelowna, Langley, Nanaimo, Prince George, my office in Richmond, Terrace, and Victoria. And we also have online, we have interpretation guidelines, which sort of, the act sounds, it's got like jargon. And so we do have interpretations that kind of explain in more plain language and provide examples of situations that have come up where it's like, okay, well, this is what the act says, and here's how it was applied, which can be really helpful to people. And that's called the interpretation guideline. Also, you can find that on our website. And the last slide I have is just this, and this is just to say the Employment Standards Act is just one area. We deal with wages, but there are other issues that come up in the workplace or other clarifications employers need, and it might be about, protected rights, and that's Human Rights Clinic, taxes, Canada Revenue Agency, requirements for health and safety in the workplace, that's definitely WorkSafe, or Service Canada, and that can be, they also are involved in some of those protected leaves with employment insurance. Also, if the federal program, Service Canada can also help with anything to do with LMIA, so labor market impact assessments, or those aspects of employment. And that is the end of this. Is there any other questions or things that I didn't address that people would like to ask?
Hi, Courtney.
Hi.
Back here, can you hear me?
Yes, I can.
Do you ever get conflict with temporary foreign workers, either the SOP program or the AgStream program, or is that strictly governed by the contracts that they enter into?
No, we do absolutely do. And we do have another piece of legislation. I didn't raise it here, but we have the Temporary Foreign Worker Protection Act, which sets out, so employers have to be registered with us to hire temporary foreign workers, to go through those programs like SWAP and LMIA and those various things through Service Canada. And they are also entitled to these same rights under the Employment Standards Act. So the same things, minimum wage. Their contracts, like, the ones that you see through seasonal agricultural program, those are always in keeping with the minimum standards of the act, like the templated language. I know that sometimes they fill them in province to province, but those should also meet the minimum standards. But they also have the same ability to file complaints or any of those pieces. But yeah, they have the same things as the act for sure. And we do see a lot of temporary foreign worker complaints coming through, or a lot of questions, because obviously there is extra confusion sometimes that happens just with a foreign worker because there's more programs involved.
Excellent, thank you.
Yeah, no problem. We do also offer, we have these kinds of sessions on our website, and we do have some that are specific to hiring foreign workers, which can be really helpful as well.
Where would we find that information? Is it just a matter
on
of
our website? Yeah, so let me go back my slide. So this is our website, that's the IGM, but here, this is our website, so the Employment Standards branch. But also, I always just, because like, I don't know why we don't have a more simple website, thank you, government. But if you just look up the Employment Standards branch, British Columbia, you'd find our site. And you'd be able to see like any more of our sessions we offer. Also, even contacting us through there if you have something specific where you're like, hey, I don't know about this. Like, is this okay? Does this raise any flags? You can always give us a call at those, because we do have a public number for those inquiries. Is there any other questions? No? Okay, I think that's it.
Okay, so I just want to say thank you, Courtney, for taking the time to come and share with us today. This session was definitely very informative, and I thank the attendees for taking the time as well to come and spend the time with us and to get this information. As it relates to, well, the numbers are shared here. If you want to get additional information, also Courtney has offered that if there's something specific that you wanted to verify, you can always send me an email and I'll forward that on to her and she'll answer as quickly as possible. She just doesn't have an email that she can share with the wider public, just because she's most times tied up in like investigations, etc. Okay, so again, thank you all for coming. And as we go through, the session is recorded, so we'll be sharing the recording with the attendees, and also it will be on our website if you need to check back at a later time. So if there are no other questions or comments, this is where we'll wrap up for today. Thank you again, Courtney, and we'll definitely be in touch.
Thank you so much.